is Tina Huang. I'm a director of Queensley Law. I'm also the leader of the Property and Disputes team. Today we're going to be talking about dog charges. So I'm very sorry to hear if your dog has been charged under the Dog Control Act 1996. This means that it's a criminal charge against you, the owner, or the person that was in charge of the dog, and there are 5 things that you need to know. Firstly, where is your dog? If your dog has been involved in a serious incident, it is likely that your dog is in the custody of animal management. You have one shot to apply for the dog to be released to you, and there are often conditions that apply to any release. So if animal management say no, then you have to actually go to court to appeal that decision. So you have to ensure that application is done right the first time. Number 2, what section have you been charged under? Section 57 is for an attack, which means that if you're charged and found guilty of that offence, then your dog will be subject to a mandatory destruction order unless you can prove exceptional circumstances. There's a Court of Appeal case that makes it really hard to prove exceptional circumstances, so it's going to be really hard to save your dog if you're under that section. Section 57A is a rush charge, which means that if you're found guilty of that section, then the dog is subject to a discretionary destruction order, which means that the judge may or may not order, and so it's easier for you to save that dog under that section. Thirdly, we have to look at priority. Is your priority saving your dog? Is your priority saving yourself? Or is it both? Depending on what your priority is, your strategy might change and your options will differ. Fourthly, here are the options and steps you may be able to take. Number 1 is diversion. So if this is your first time offence, the dog has not been involved in any incidents previously, you may apply for diversion and get this. Secondly, you might be able to apply for total absence of fault, which means that you won't be found guilty of the offence. Thirdly, you might be able to plead not guilty and dispute the whole charge altogether if you think that it's been wrongly done, but again, that's also very rare to do. Fourthly, you might be able to dispute the facts and say, I agree part of what's happened, but not all, which means that you have to go to a disputed facts hearing with counsel, and that has various steps that you need to take. You might be able to plead guilty and mitigate the penalties and costs and say, yep, guilty, yep, my dog was involved, but could we please decrease the penalties and costs because of certain steps that I've taken, and that might be available for you. Also, you might be able to plead guilty but apply for exceptional circumstances if you've been charged under 57. So those are sort of cases where your dog has been provoked or gone out in self-defense of you, but it's a very high threshold and difficult to make. There's that current Court of Appeal decision of Hill, which makes it really difficult to do. I recently went to the Supreme Court to try to challenge that decision and unfortunately lost. So that Court of Appeal decision stands and makes it very difficult to win on exceptional circumstances, which previously was easier to do. Lastly, you can plead guilty but apply for a discharge without conviction, which basically means that, yep, you're guilty and yes, it happened, but could you please be discharged because the consequences of the conviction far outweighs the gravity of the offence. So that could mean that if you're applying or studying to become a lawyer or chartered accountant or some profession that cannot have a conviction, yet the actual offence was quite minor, you might be able to get a discharge without conviction. A recent Court of Appeal case, Telford, says that if you get a discharge without conviction, then your dog will no longer be subject to the mandatory destruction order. You might be able to save your dog this way. So number 5, as you can see, the process is quite complicated and you need to get good legal advice. Unfortunately, I've seen some clients come to me after their previous lawyer screwed it up a little bit, and I've had to, for instance, appeal a decision from the District Court to the High Court based on misguided advice and the District Court ordering conviction and destruction of the dog, despite the lawyer saying that that won't happen. So I've had to go to the High Court to appeal that, won that, gone back to the District Court to review that sentencing, apply for a discharge without conviction, save the dog, save the client, but it took over a year and a lot of legal fees. So you want to do it right the first time. If you want good legal advice, please come and see me. Thank you.